Man, things have changed covering college athletics from what were wins and losses and maybe coaching changes and recruiting to the transfer portal, NIL, antitrust lawsuits, and, of course, realignment and so much more. Mitt Winter Sports Law on Twitter, NIL Attorney, also sports law attorney, joins us on 365 Sports with Paul and Craig, David Smoak. Mitt, thank you for your time. So what right now is the number one, I guess, legal issue the NCAA should be most petrified about?
I don't know if I could narrow it down to one. I'm going to go with, I'll go with two. Number one is just antitrust litigation in general. I'm sure you guys are familiar with the House case that is pending, and it has a potential damages number in the multiple billions of dollars. There's a new antitrust case filed by the same plaintiff's attorneys as the House case, called the Carter case. That shares some similarities with the House case. And then actually the transfer rule case that just happened on the federal court in West Virginia that doesn't allow the NCAA to enforce its transfer rules anymore is also an antitrust case. So definitely antitrust law and litigation in general. And then I would say the employment issue, whether at least some college athletes are going to be declared employees at some point. There's a couple of National Labor Relations Board proceedings that are ongoing right now that are going to answer that question for us. And then there's also a case pending in federal court called the Johnson versus NCAA case on the employment issue as well. So to me, those are the two big things, just because they're going to have a really big part in determining what the model for college athletics is going to look like moving forward.
So, Mitt, how do they how do they get an antitrust exemption? Does that seem likely or unlikely now? And when they do that, does that mean that they probably just need to come to grips with the fact that they're going to lose on the employment thing too?
Yeah, in terms of the antitrust exemption, there's really two ways. Number one, they could get a federal law passed that provides them with an antitrust exemption. And that's what the NCAA and conferences and some schools are lobbying the federal government to do right now. They've been spending a lot of time in Washington, D.C. With that lobbying effort. I personally don't think that will be successful, at least this year. The second way they could get an antitrust exemption is if they collectively bargain with the athletes. And for that to happen, at least some athletes would have to be employees. They would have to form a union. And then when there's a union and an entity that negotiates with that union, collectively bargains with the union, and they agree on rules like a salary cap, player movement, things like that, those rules under labor law are immune from antitrust law. So that's how in professional sports you have things like a draft, like the salary cap, like I mentioned, and free agency periods and all that stuff you have in pro sports, is because those rules are collectively bargained by the players, unions, and the leagues. And so it makes them immune from antitrust law.
Mitt, with your background, obviously in the legal profession, how much have you had to ramp up a little bit with what NIL, transfer portal, all of what is going on now, realignment in college athletics? Yeah,
I'm kind of in a unique situation. I mean, obviously NIL is new, and so it's a couple years old now, but when it first was allowed, it was new for everyone. But I had sort of been in a position that I didn't have to ramp up as much as some people. I had been working in college sports legal space for a pretty long time. And I'm also a former college athlete. I played basketball at William & Mary, so I had that background as well. But I had actually represented the NCAA in some matters and the Big 12 and Conference USA. And so a lot of the cases I had worked on were kind of like the cases that led us to where we are now. Like I worked on the O'Bannon case and the Alston case, and even a precursor to both of those cases called the White versus NCAA case. And all of those were about college athlete compensation and, in NIL in a way. I also worked on a lot of conference realignment stuff when I was working for the conferences as outside counsel, because the Big 12 and Conference USA have both been conferences that have had a ton of conference realignment over the past 10 years. So I've kind of been like perfectly situated, which is with my personal and professional background, to kind of like jump into this stuff pretty quickly and be pretty knowledgeable about it without having to have a big ramp up period, which has been helpful for myself.
So when you look at a situation like the ACC has right now, with Florida State being the loudest and the one who's about their position in the conference, with a grant of rights that lasts another 12 years, is there anything that they can do, or like, how do you see that playing out? Because all the other conference realignment things happened when those agreements were about to expire. This one has 3 more presidential elections in it.
Yeah, the grant of rights is obviously a big issue there. And I think at some point, if it's not Florida State, it'll probably be some other school in the ACC that tries to either just say, all right, ACC, we want out of this grant of rights. Here's how much we're willing to pay you. And they'll just negotiate some sort of exit agreement. Or if the ACC is not willing to play ball on that, I think there could be a point where Florida State or whoever, somebody's going to challenge the grant of rights. When you have all this conference realignment stuff, and especially with the grant of rights, a big issue is what's known as sovereign immunity. And so when you have state universities like Florida State, things can get kind of tricky when you're trying to enforce something against state university, because they're considered part of the state, and sometimes it can be hard to sue a state. So that would be an issue that would come up. I know that Florida State and other schools have had their attorneys look at the grant of rights and consider ways that they could attack it. So I'm sure if it gets to that point, they already have their strategies mapped out on how they're going to do that. I think it would be difficult to defeat the grant of rights in court, but nobody likes to be involved in litigation for too long. And if it got to the point where there is litigation, maybe it would push the ACC to reach some sort of settlement. But it'll be an interesting, scenario if it ever does get to that point.
Mitt, correct me if I'm wrong, but you said you were working the O'Bannon case. Were you working it for the NCAA on their side or for O'Bannon and his side?
Yeah, so it's interesting. I was on the conference side, which was basically the NCAA side. So that was when I was working as outside counsel for the Big 12 and Conference USA. Now most of the stuff that I do is on university side, represent some NIL collectives. So not necessarily the total opposite side, but definitely different than the NCAA and conference side, which is what I had been working on previously.
I want everyone to know that we're talking to the guy when the Big 12 sent ESPN a, hey, shut this down thing, when there was thoughts about maybe tampering or whatever, collusion, or I'm not sure, that's probably not the right word. You were in the middle of all that back in the fall of 2021 after Texas OU and Mike Oresco and the American Conference, et cetera?
I had actually gone to my current firm prior to that. So I left the firm that I was at when we were representing Big 12 in 2019. So I was not involved in that realignment saga, but I was involved in some of the prior realignment stuff that the Big 12 had going on.
Well, they've only had like 20 of those stories.
Yeah, it's like never ending. So.
When Bob Bowlesby did that, though, how strong of a move was that? Because that did seem to slow things down dramatically and give the Big 12 a chance to respond.
Yeah, I think it helped the conference for sure in rebuilding. I don't know how much ESPN was actually scared by that threat, but it probably helped keep the conference together and give them something to rally around, and then get their plans together on how they were going to move forward.
Mitt, when you were involved in the O'Bannon case, which is, I mean, the historic one that started the wall tumbling down. When did you see the tide start to turn? And then when the decision was made, did you see this as the inevitable outcome of what was going to happen to college athletics?
Yeah, that's a good question. You can kind of tell just throughout that whole case. That was the first case that, Judge Wilkin, who was a judge in O'Bannon and Alston and is the judge in the House case that's pending now. So this was that was her first college athletics related case. And up until that point, generally, courts had been pretty receptive to the arguments about amateurism and had been really deferential to the NCAA's athlete compensation rules. And you could just kind of tell that Judge Wilkin was not necessarily buying those arguments like courts had in the past. And at the trial of that case as well, you could tell she was really, really skeptical about things. And then once the decision came out that found that the NCAA's rules that did not allow athletes to monetize or NIL at all violated antitrust law, that was a huge decision. It was really the first case that found the NCAA's athlete compensation limits did violate antitrust law. And personally, myself, I thought that would probably lead to some more change than what actually occurred leading up to Alston. But it didn't change a ton from like the NCAA and conference perspective. I think they kind of just thought it was this one-off decision, and it was an outlier. I also think that they thought they'd be able to get it overturned on appeal, which it was appealed to the Ninth Circuit, and a little bit of it got overturned, but most of it got affirmed by the Ninth Circuit, and it never ended up going to the Supreme Court, even though both sides asked the Supreme Court to take the case. It declined. But yeah, that was really the beginning of getting to where we are now with the NCAA having all kinds of antitrust problems. And it was really all because of O'Bannon, and then Alston went even farther than that because it did go to the Supreme Court and they lost 9-0.
How much would you say, Mitt, we appreciate your time, how much would you say where the NCAA is today? It seems like they got darts being thrown from every direction. Is stubbornness that they should have known better 20, 25 years ago, or they just thought this was never going to happen?
Yeah, I do think that a lot of people in leadership positions never thought we would get to a point where we are now. And I do think if 20, 25 years ago, if a plan would have been put together where athletes would have received some sort of direct compensation, and that model was blessed by Congress with, kind of what they're asking for now, that says we get an antitrust exemption and college athletes cannot be employees. 20 to 25 years ago, I think Congress probably would have been really receptive to that. The general public would have probably viewed that as, a really good deal and a fair deal. And I think the chances of that happening would have been a lot higher than they are today.
Mitt, we appreciate it. What are your thoughts about the Power Two trying to separate, whether it's in the next 2 to 5 or 7 to 10 years, as the SEC and the Big Ten? What will that do?
Yeah, that'd be an interesting scenario. I think something that could push things in that direction is if and when at least some college athletes are declared employees. I think that could really be an impetus for those two conferences and maybe some other schools, teams as well, to kind of say, all right, we really need to get serious about something that's totally different than the way we're operating now. So let's examine a breakaway from the NCAA and really just start our own governing organization, at least for our football teams and maybe some other teams. But I think that could be a really big turning point there with the employment issue that could push things in that direction.
Thank you, man. Love the follow on Twitter. Again, at Mitt Winter Law. He is with us. Thanks for your time, Mitt. Have a great week, and with all the things that are going on with the NCAA college athletics too.